Thank you very much.
Yes, you may record, that's not a problem. So in terms of how this is playing out, I guess, in the public domain, you just need to look at the media. And from some months ago, this concept of AI in public general use, of course, hit the newspapers and the news services, but particularly through ChatGPT and the use of devices or applications of AI that are generating content then that can be used in academic institutions such as universities, schools, to cheat, to provide assessment material which is not written by students but is in fact generated by AI. So we're talking here about generative AI applications. Now, I'm sure this is familiar to you in Brazil. It's a worldwide phenomenon. But it sort of led, I think, a fair bit of the public concern over how quickly things are moving. And this really did move very quickly. And then the question, well, how do we respond to it? Do we respond technically? Do we respond legally with regulation? For example, the prohibition of the uses of AI in classrooms or schools, or do we respond in some kind of more measured and social way? So that's one example. Another example, I'm sure you're familiar with this also, creative industries and many industries that depend on the creation of content are also seemingly quite threatened by the intrusion and adoption of AI technologies that can replicate and in many ways just take from what's been done by humans and reimagine it, repackage it in a way that for some people is quite indistinguishable. So, you know, there's a strike on in the US as we speak amongst writers and creatives in the movie industry. And part of their concerns are being replaced by AI in terms of creative output, or for many people such as artists and so on, is having their creative identity in fact stolen and then reproduced by AI assisted means. By the way, all of these things I've taken from newspapers, all just from this month. I haven't had to go back very far. This is just all in the media just in the first few weeks. Half of Australian lawyers fear that AI will take their jobs, according to research. I'm not sure whether that's a realistic concern or not, but apparently it's a concern amongst those who are surveyed, that employment could well be threatened or severely transformed by AI introductions into these kinds of industries. Of course, no doubt seen references to robo-judges who will be replacing me in making decisions on appropriate sentencing and so on. I mean, there's lots of examples of where people have at least considered these as possibilities, if not introduced anything in practice. This is more towards the area of criminal law interest for me. So that lady in the picture there, she's our e-safety commissioner. It's an office that's more or less unique to Australia. It was introduced as the Children's Online Safety Commissioner, and then it's become a bit expanded in the role. So the legislation is called the Online Safety Act. The office is called the Office of the E-Safety Commissioner. And it's quite a powerful package of legislation that can be used to attempt, at least, to protect against harms online. Anyway, here's a headline from just a week or two ago, saying, according to our e-safety commissioner, that AI is being used in child sex abuse offending and in the grooming of children through targeting them through realistic chats and so on that learn quickly how to converse in the language of younger people in a way that is very convincing to them. So it's being adopted by, apparently it is being adopted by, or may be adopted by, those with malevolent intent. And of course, there's the emerging issue of deep fake pornography, child abuse material included, but also directed at adults in a way that's part of harassment, stalking, and so on. Right, so they're just some of those kinds of head. I mentioned that there are some current inquiries going. For example, the most populous state in Australia, the one with the greatest population, is New South Wales. The capital is Sydney. Where I am, Canberra is the national capital, of course. So this is our Brasilia. They're running an inquiry at the moment. It was established in June. Inquiry into artificial intelligence in New South Wales, but particularly looking at things like adequacy of laws and regulation. It hasn't produced anything yet, so I have nothing to report to you from that one. Established in May is another inquiry in a sector-specific inquiry. That's inquiry into the use of generative AI in the Australian education system. And as I said, that's responding to these problems of cheating and integrity of assessment and of the education system and standards, the integrity of degrees and all of these things that are quite important. It's a big industry in Australia because we have a lot of foreign students, and it produces income, of course, for Australia, and it's vulnerable to, of course, instances of cheating or undermining of standards and so on. The one that is probably most interesting is a national or Commonwealth level inquiry about supporting responsible AI. Now that's taking a more positive approach. It's saying what kind of regulatory and other frameworks can we have that will support the responsible adoption of AI. So it's not trying to resist it, it's just saying, well, how can we introduce it in a way that is beneficial and responsible. So I think that one it's got the most detail so far in terms of producing a discussion paper that I was just looking at briefly. I won't have it up on the screen now. But it's talking about that mixture of some hard law, some softer law in the forms of regulations and standards and so on, and then quite a lot of just industry level optional guidelines, best practice models and so on. So that regulatory hierarchy or pyramid that theoreticians will be familiar with, from the harder to the softer approaches to law. It's also involved in an international comparison, and I've seen sort of within that discussion paper is a chart that maps out what the EU is doing, other countries, US and so on. Within that framework, Australia doesn't have any legislation that is specifically and only dedicated to AI. We don't have an AI Act. I understand something like that is has been developed, perhaps is already enacted within the EU as a directive. I'm sure Juliana will tell us more about that. And some other countries are looking towards more specific legislation. In Australia, we're still at the level of having some references to AI in discrete parts of our legislative framework and in working out what already can be applied to AI and what needs to be modified so that it will apply. For example, a reference is made in that discussion paper to the Online Safety Act, and it, I think, concludes fairly plausibly that the powers in relation to harmful material online will apply equally to material that's generated through AI technologies such as deepfake, child exploitation material, that it applies just as equally to that as human produced All right. Now I'll go through this. This is another media grab again from just this month. But we're at the stage of Parliament nationally in Australia apologising to the victims of robo-debt. So robo-debt is this program that I want to discuss now. What it is, or what it was a program that was designed in order to assist the detection, investigation, and deterrence of suspected welfare fraud and non-compliance. So a program was announced back in 2015, basically to target social security fraud and overpayments. So what was rolled out 5 years ago was this automated, it was called the Online Compliance Intervention, or OCI system, known throughout Australia now as robo-debt, like based on a RoboCop, obviously. Now, this system was based on averaging, so it estimated how much people may have been overpaid by the government and imposed then a debt recovery burden on them based on kind of an averaging calculation. The government was hopeful or publicised that this automated system would claw back some $4 billion in overpayments to social security recipients. It's done no such thing. It's had quite the opposite effect. As soon as it was rolled out, people started saying, but it's wrong. It's sent me an assessment that just can't be correct. It's not what I've been paid. It's not what even I earn. It's just wrong. And many individual cases of overpayments began to emerge. And some quite tragic stories of people who were so stressed and upset that they became ill. Some people committed suicide when they were sent these demands for money that they didn't believe that they owed at all. But, the response was, well, the computer says you did. Well, within about 2 years, there were so many errors reported and found, the program was suspended and it was ruled unlawful by our federal court. So that's a pretty short turnaround for a big government program to be rolled out, to start failing catastrophically, and then to be found to be unlawful. 2 years later, the federal court approved a 1.8 billion class action settlement that almost completely wipes out anything that the program ever recovered for the government. And just this year, in the last month or so, a royal commission into the scheme has recommended criminal and civil proceedings to be brought against senior government members who are responsible for rolling out this program. So this, in terms of public acceptance of automated decision-making within government, AI generally, perhaps within industry, this has left a pretty bad taste in people's mouths, I would say here. I don't know whether you have any similar experiences in other countries. So what was particularly wrong with this? So it was an algorithmic matching of recipients' reported earnings with averaged income data from the tax office to alleged then overpayments. It had little to no human oversight. The calculation method, though, was fundamentally flawed. And according to some of these just grabs from media, what we've learned from robo-debt, the problem with it was a human failure at mathematics. Whatever the motivation, the maths used for estimating income was wrong. And that, according to one commentator there, he says, well, that's not an AI problem, that's a human failure. So it doesn't necessarily condemn AI, but it just shows that it does have to be rolled out with due care. Another commentary there from Australian Financial Review, there needs to be a sensible pathway to appropriately automating public service processes with proper management and protocols. So accountability, human oversight, and so on do seem to be indispensable if you want to have trust in AI systems that are rolled into things like public decision making. A bit of that's missing, but it raises the question, do we need new laws for AI, but sure, first let's try enforcing the laws that we already have. And for me, that's actually quite interesting, is, you know, to take laws that are designed for human interaction and just say, well, how will they apply if we seek to apply them in an AI kind of context? So now I'll take you into this second topic that I wanted to talk about, and this is not specific to Australia. This is a bit more of an international dimension, but I'll come to my small part in it. So this chatbot, you can see it's there's a picture of a girl there. She presents as a 10 or 10-year-old girl, I think, called Sweetie. And originally she was run as a manually operated avatar in chat rooms frequented by child predators who are engaged in what's being referred to as webcam child sex tourism. So instead of traveling to a country to abuse a child, they can stay where they are, order through video cam, live sex shows or displays, or live streamed abuse and so on from places like the Philippines, especially. So an initial experiment was conducted some years ago, and there were 4 operators of one avatar. So, you know, not a lot of coverage there, but went into chat rooms, and they had something like 10,000 hits from predators around the world in something like 6 weeks. A number of those, quite a number of those, were readily identifiable. They used their own identifying information, including credit cards. Some of that was reported to police. Some police took action. The first prosecution based on that happened here in Australia, in Queensland. Well, the second version of it, 2.0, became much more automated using AI, and it's a program that, again, visually, in conversation, in chat conversation, presents as a child online, and can have a text recognition, detection of similarities and so on, probably identify that a person using this alias is likely to be the same as another person using a different alias. It can do a lot of interesting analytic work. So the question then arose, and this is where I got involved in it. People were saying, well, this has been run by an NGO called Terre des Hommes as an experiment, really. Could it be a technique adopted by law enforcement, that is, to use AI programs to detect cybercrime in an automated way? And that's an interesting legal question. That's just a little slide that talks about the more advanced version of Sweetie, a fully autonomous artificial intelligence that can engage in meaningful conversation with the suspect, and it's infinitely scalable. So that's the power of it. Now, could something like a Sweetie 2.0 AI chatbot be used by law enforcement? So that book there came out in 2019. It's a comparative study across, I think it's 15 or 20 countries, including Australia, about what the laws are and whether they would allow this kind of technology to be used by police, by law enforcement. The answer that I was able to give for Australia is, this is not much of an extension legally from what police are already doing when they go online with an assumed identity of a child and pretend to be a child. We don't have a defence of entrapment in Australia. We do have some standards about illegally or improperly obtained evidence. There's nothing illegal about adopting these kinds of covert techniques online in the pursuit of a criminal investigation from our perspective. So my conclusion was this could be used by police, and I've talked to police in Australia about whether they'd be interested in using this kind of advanced technology in investigations. They're a little bit wary of it because police like to keep control over their investigations, and this is, to their mind, a bit like a web crawler, that you don't know what's happening, you don't know what is being done out there, and they may not have sufficient control over it. The other part of it is that there are some things for which warrants are needed, and in particular, this would be seen as a surveillance device. And for surveillance devices, they must get a warrant, and the warrant has to be fairly specific in what it's targeting. That said, just in the last year or two, we have a range of powerful new warrants here in Australia for police that you might or might not have anything like it in other places, but data disruption warrants. This is now basically allows police to hack back and to knock out websites, even in other countries, potentially. So things like ransomware groups. So data disruption, takeover. So taking over the accounts within organised online crime and so on, and then running an account to detect illegal activity by others. Network activity warrants, where potentially very wide networks can be monitored. So it's really getting quite high tech, the kinds of things, plus of course computer search, seizure, and so on, warrants, including remotely. All right, so that's an interesting, I think, potential use of AI. Obviously, to the extent that AI can be used in crime, it will be used in crime. To the extent that it can be used in fighting crime, in law enforcement, I think it probably needs to be as well. So a question then is, well, what should be the parameters? What kind of regulatory structure would you impose on that? So I think I'm going to stop talking there and just give a couple of references to things that I've been involved in, a couple of cybercrime or technology and law books and so on. And I think the most specific paper was one from just 2 years ago or so, legal considerations in the use of artificial intelligence in those kinds of investigations. I'll leave it there, and I'm really happy to hear from you as to whether any of this has parallels in jurisdictions that you're familiar with, or the debates, the developments, and so on. Thank you. I think you're muted.
Thank you very much, Gregor. Well, I have some questions. If you could go back to your slide where you indicate some of the initiatives on the regulation of AI. Yes, this one, current inquiries. Yes.
Yeah.
As I understood.
What I might do is I'll just stop the sharing of that, and I'll see if I can actually get one of those inquiries up on the screen.
Okay.
Please go ahead and ask your question anyway.
Yes. Well, so there are mainly two approaches in the international scenario about regulating AI, and there is the US and UK approach, where the federal government just provides some directives and the main values to be protected, and then there is initiatives of regulation by regulatory agencies. So there are public rules and public enforcement of them, but they are all sectorial and related to regulatory agencies to some fields. Then there is the European approach, which is transversal with a general regulation that imposed some obligations for the managing of risks by the companies which develop and also which deploy AI systems. So as I understood, the Australia approach is closer to the North American and UK approach, where there is just a discussion. Actually, the discussion is, as I understood, is on its infancy. It's just established in the parliament, and but it seems to be more like the North American and UK approach. So what I would like just to clarify is whether there is also this tendency to delegate for regulatory agency to establish some obligations on governance of AI, or the tendency, the trend is to leave it to self-regulation by company organizations, and because there is these two ways: either you provide the main guidances, and then self-regulation establishes in more detail what are the governance main procedures to responsible AI, or you delegate it to regulatory agencies. In Brazil, we have two proposals: a proposal by the Chamber of Deputies, where they have this more general approach with directives, and then delegating for public and regulatory agencies to provide more detail on the governance rules for AI. And there is also a proposal by the Brazilian Senate, which is closer to the European approach, where there is a more, it's not as detailed as the AI Act, but there is an indication already of which are the main procedures that should be adopted by companies who developed or deploy AI system in order to manage risks. So I just would like to know what's the way that is being followed in Australia, whether it's the self-regulation approach, or is it delegation for regulatory agencies?
I wish I could give you a simple answer, and I think there are two complicating dimensions. One is Australia is a federal legal system, like the US and some others. I'm not sure how much federalism there is in Brazil. There may be some divergences, but in Australia they can be very significant. So one area of uncertainty then is whether any regulatory approach will be done mostly at the federal or Commonwealth level, national level, or it'll be done at various state levels. And you saw that one of those inquiries is in one of the states. So it could be that an approach is adopted in one place that's not necessarily going to be replicated everywhere. That's one complication. The other complication is that it really depends, I think, on which kind of AI context is being considered for regulation. Some of them will be seen to have much more security risks, possibly financial risks, health risks, and so on. Those ones are more likely to get the top-down approach, that is, prohibitive regulation. And so
Gregor, we lost you for some seconds. Could you repeat that?
Okay, did you lose just my audio or the whole link?
No, the whole. But it was just for 20 seconds, something like this.
20 seconds. Okay, I'll step back. So I talked about federal complications, the federal system, so that we may not have a national approach. It might be more piecemeal. The other thing is that a lot depends on the assessment of risk and security and so on. And I'll give you an example of that. We do have, for example, gene technology regulation, genetically modified organisms. That was done by passing a national piece of legislation, and each state, each jurisdiction passed the same regulation. So we have a mirror setup, and it's prescriptive. It says that gene technology is illegal. I mean, not that simple, but genetically modified organisms. And then come the exceptions, if it's done under license through a central regulatory body. So that's that approach. That could be what is done with AI, at least in some sectors, potentially. On the other hand, we've got other approaches to other types of industries or industry problems that are much more voluntary, opt-in, code of conduct sorts of things. I can't think of an example straight up, but in some instances, it's not possible to regulate successfully, particularly where there's international dimensions to it. So I mentioned the e-safety commissioner. Well, how does the e-safety commissioner have any power over what's posted on social media that are hosted in other countries? Well, it's through essentially high-level voluntary undertakings by, Facebook and other social media apps and so on. But if they want to do business in Australia, then they have to have some kind of responsiveness to complaints that are made about material, and they have to act on it and take material offline after assessing it. So it's that kind of, I think, balance between top-down regulation and responsive regulation that I think will be rolled out in Australia. I can't give you a more precise answer than that. I'm sad to say.
Oh, well, we have a question here by Rony, but I will give some steps back before posing his question, because it's related to what I was willing to ask. It's interesting that the inquiry made by New South Wales is first to discuss whether the present laws and regulation are enough for dealing with AI. Because, for instance, here the discussion in Brazil was, the first reaction was we need the regulation. So let's discuss the regulation without testing whether our laws are enough to tackle with the AI the problems that AI pose. So I think this is an interesting approach. I would like first to ask if there is a document, any document published that propose and have some considerations about this approach. First inquire whether the laws are enough. Actually, in the Logarithm Institute, we have a project called Future Precedents, where the goal is exactly to discuss this question. But our approach was to create some conflicts involving AI, just to touch on pressing issues regarding the regulation of AI. And we will now bring some important judges in Brazil to decide those cases. So what we want to understand is whether will they be prepared to decide cases involving pressing issues of conflicts involving an AI. So I think this question is very important. I myself have written a paper about what the data protection legislation could contribute about regulation of AI. So I think this is really important, and this comes to Rony's question. Question is which is the news on the creation at Spain of an AI agency which would then enforce rules involving conflicts about AI. And there may be overlaps with other authorities. And so could that be a solution where instead of first providing rules on AI, just to create a specialized authority to consider the new questions that are raised when you are facing conflicts involving AI?
Yeah, possibly. I suppose that as a national kind of approach, the Australian approach is not normally to set up large-scale bodies and then try to work out what they will do. It's a bit more problem-oriented. So that might be something to be considered down the track, something like a ministry or agency that has some specific functions in relation to AI. I don't see that emerging for quite some time here, if it ever does. I think it's much more that specific thing about looking at adequacy of existing laws and regulation. So an example might be something like transport regulation, right? Transport is very heavily regulated. It's, there's all kinds of licensing and lots of rules and regulations. Some of them bring people before courts, like the one I'm sitting near here. And people are obviously looking at all of those rules that are in place already and asking, would this apply to automated vehicles, autonomous vehicles? Right. So that's much more, I think, realistically where this focus or this kind of focus will be. Take an existing sector that's already regulated, introduce AI or possible AI, and just try to work out whether that would already be covered by existing laws and regulations, and if not, what extra has to be added. Similarly, with things like drone delivery of food to people, there are many examples of kind of new technologies where the first point of contact is to look at what is the existing legal architecture and how does this challenge it. So what's disruptive about these technologies? I mean, and if you think about something like education, right? Most of us have worked in universities. We know about students who cheat. We know when they claim that something is their work and it's not. Well, that's a false claim. It's grounds for giving them a bad mark or even, kicking them out of a course. The same is true if they claim to have written something that's generated or produced by AI. It doesn't really change the fundamental problem there, which is a problem of dishonesty in the claim that's made. The fact that something has been generated by AI is a kind of peripheral to that.
Yeah, interesting. It's quite a different approach.
So in terms of detection, then you've got a whole different set of problems, because we have systems like, Turnitin and so on, that will detect similarity of works, that'll detect collusion to some extent, but it won't, as far as I know, successfully detect AI-generated original work. So our systems of detection and enforcement may not be up to the task.
Okay, very interesting, because it's quite a different approach from our approach here in Brazil. It seems to be much more careful, studying for each sector, what is the regulation, what should be supplemented to tackle problems relating to AI. Diego, please. You have raised your hands.
Yeah, but I put my hand down, Juliano, because when and thank you so much for your presentation, Professor. It was really enlightening, and especially when you mentioned all the different sectors and all the different regulations that apply and the cautious approach that is needed. Because my question in the beginning, perhaps it's not valid anymore, was the following. And full disclosure, I work for Facebook, and what kind of AI systems are we talking about? Because through the course of your presentation, you basically mentioned AI systems that happen to operate at the upper layers of the internet, right? At the interface with individual users. But in this group, we have different entities that operate down the stack, that use and rely on AI for much more infrastructural components of different sectors of the economy, not only social media platforms, not only, I don't know, technology companies, but we are talking about transportation, we are talking about aviation, we are talking about health services, and so on and so forth. And my question to you would be the following. Is the debate around AI in Australia also contaminated by this alarm around social media platforms? Is the debate in Australia focusing only at the tip of the iceberg with this sense of urgency of doing something to regulate AI, this AI that is related to the direct interaction of users, running the risk of just like adopting broad brushes to regulation that are going to affect much more infrastructural components of society without having clarity on the concept of AI and all the different dimensions and components and so on and so forth? Or do you think that in Australia the debates are much more cautious about the 50 shades of gray in the concept of AI?
Okay, that's interesting. I think that the public concern that is reflected in those sorts of media reports that I was saying, of course, the media have to catastrophize everything. So, you know, that's looking at the potential harmful effects of AI at a visible level. Nobody's really talking about, and this is perhaps the, you know, the stuff that is not the tip of the iceberg, but the bulk of the iceberg, and that's the many applications of AI that are simply invisible to ordinary people, but, you know, determine when traffic lights change and lots of things about systems and so on that actually make our life better. So, at least in theory, there's no reason why those sorts of AI applications should be resisted or, you know, concerns expressed about them in the same way that these higher level stuff like, you know, cheating students or, you know, child exploitation material and so on, that has a capacity to alarm the public. I'm sure that there is a lot of AI that's being used, introduced, and so on in those kinds of systems that you're talking about that nobody ever knows about, or the public doesn't know about. And if it was given an opportunity to think about it, but would not be concerned about it. You know, things that make agriculture more efficient, things that help with financial auditing and accounting and so on, those sorts of things. But it's where something goes wrong, and visibly so, like the robo-debt example that I gave you, that, of course, it creates a lot of public concern and backlash. And maybe, you know, maybe the backlash against AI there is misdirected. It's really that it was done, you know, an automated program without sufficient oversight is really the problem there, rather than, I suppose, the particular technology that was used.
Yeah, and Juliano, if I may just do a follow-up, Professor,
Please.
thank you so much for your comment. Juliano mentioned the US approach, the European approach, and the approach that was proposed by this committee of legal experts here in Brazil. And one of the details that I wanted to highlight based on what you just said is the following. In our proposed bill, there is a blank right to explanation that does not make any reference to the different sorts of AI systems. Basically, the proposed bill is granting Brazilian citizens affected by AI systems a general right to explanation. So if I can make the case and create a causal link between an agricultural system, the food that reaches my table at the end of the day, by this proposed bill, I will have a right to get explanation, transparency, and details of the AI system that was used way down the chain of production, because there was an AI system involved. I mean, what I was talking about, this idea of regulating AI with very broad brushes, granting general rights to affected users. When we have a fundamental scene in the AI discussions, as you correctly pointed out, it is very hard to define AI, and it's very hard to see all the dimensions in AI in the very infrastructural components of society at large. So I praise Professor Juliano here, because what he's trying to push us all to discuss at this level of industry, academia collaboration is basically getting the fundamental concepts right. And I thank you so much for helping us move forward the needle towards a better solution to our concerns, doubts, and anxieties. Thank you.
Actually, later, Gregor, I'm going to send you an English version of this proposal by the Senate, and it follows the European approach, but there is something new that was introduced and provokes this problem that Diego has raised, because it's not only proposed a system of risk management with procedures. Minimal procedures to avoid AI risks or to mitigate AI risks, but there is a chapter on rights by the citizens, and it more or less repeats those obligations for the companies before the AI authority. It replicates as rights to citizens, and this makes it all confusing. Because, for instance, the citizen would have a right for explanation of a system of AI, for instance, in an airplane. So, if I'm going to travel by an airplane that uses AI, I would have the right to explanation, which sounds more or less absurd. You know?
Or the right to oppose. Or the right to oppose the use of an AI system, whatever. I mean, in very blank terms.
Well, that sounds difficult, but the other thing that springs to mind, of course, is that for some applications of AI, either currently or in the future, there may simply be no explanation available, because it is autonomous, generating its own rules, thinking, and so on. That is the whole point about it being intelligent and not robotic, in which case humans will have very little capacity to explain what it's doing, other than to say it's a black box, it's doing something. We can't tell you what, in a predictive way, what it's going to do. All we can tell you is that this is how it's currently working.
Yes.
I mean, explanation may be limited.
Yes, of course. Well, Gregor, we are already, it's already 9 o'clock here in Brazil. I believe it's 10 p.m. In Australia, or 11 p.m. I don't know.
No, it's 10 o'clock where I am, and I'll be back here in a few hours after having a sleep, putting on a robe, and then going and deciding some interesting criminal matter tomorrow morning.
Okay. So, Gregor, thank you very much for your contribution, and I hope we keep in touch to have this exchange about the Brazilian and Australian approach.
Well, thank you very much for the invitation. It's been a pleasure. Obrigado, and I hope to see you in person one day.
Okay, yes, sure. Let us make this happen.
Okay, great.
Okay, thank you very much, Gregor. Bye.
Bye.
Pessoal, nós temos então agora 30 minutos e